Just unbelievable. Just an unbelievable opinion yesterday out of our district court here. Jefferson County. Spent a lot of time on the phone yesterday over this one. And what's happened? You got to read beyond the headlines now, right? What's happened here is that by statute, I'll try to explain this the best I can. By statute, the legislature has set a maximum speed limit, right? Which is 65 or 70 or whatever, right? And that can be modified by municipalities. It can be modified by, let's say, Jefferson County, right? On the interstates, it's not something that's purely in the domain of the legislature. Municipalities can pass an ordinance that says, all right, this stretch of road is going to be 55 miles an hour and not 65 miles an hour. But Jefferson County didn't do that. They just, and this is true of just about every municipality in the state as far as I can figure out, they just posted speed limit signs. And those speed limit signs say 55, and the statute in fact says 65 or 70 or whatever. And Attorney Greg Sims, wow, he's really something. He's a wizard. I graduated with Greg, so has figured that out after God knows how many decades of this. And yesterday, Julie Kalin, who I also graduated with, pronounced it unconstitutional. Now, the interesting thing about this is...
So which speed limit's in effect now?
That is a great question.
Is it 55 or 65?
I don't know.
I need to know.
I don't know. So I think that you can still get, well, where I was going with this, there's a catch-all in the statute that says, well, if you're not driving in a reasonably prudent manner, then they can still pull you over, right? And so that portion of the statute has not yet been declared unconstitutional, although it seems impossibly vague to me. But they can still get you, so don't think that. And if you're going over 65 or 70, right, if you're doing 75 down the stretch that it says 55, you're still probably going to get popped, right? So don't get too excited about the American Autobahn in Kentucky. The procedurally interesting thing about this is what happens to this, right? So now there's been an order declaring the law unconstitutional, but they can still prosecute this guy for, I know this is criminal procedure, but it works the same way civilly, right? They can still prosecute this guy for speeding, okay? He can still be prosecuted for speeding under some other provision of the statute. So that order declaring the law unconstitutional is not final yet. Okay? So it can't be appealed yet. Okay? Everybody with me on that? It's not a final order because all the rights of the parties haven't been adjudicated yet. They haven't found the guy guilty or not guilty of anything. There is no final order. This is an interlocutory order, what we call an interlocutory order. Something that's not a final order. And so it can't be appealed yet. When it is appealed, if it is appealed, okay, when it is appealed, right? Where does it get appealed to? Ms. Pennington? Yeah?
The next
Don't you work for the county?
I do work for the county, but everything that we get appealed goes
To the Court of Appeals?
Yeah.
Interesting.
Well,
Okay.
in the two cases I work on.
Right. Okay.
So,
Who knows, right? You have a final order out of the district court. Remember, the district court is the itty-bitty court, right? Where we do speeding violations. We don't normally deal with constitutional challenges down there, right? Interesting thing. Misdemeanors, violations, small claims court, claims under $5,000, that kind of stuff. That's the district court. where do final orders out of the district court in Kentucky get appealed to? Anybody know? Who said that? Yeah, that's right, circuit court. Right? You have a matter of right appeal to the circuit court in the final order. And then you get to ask the Court of Appeals for discretionary review. And we usually think about discretionary review, which is like the petition for certiorari. And that's asking the highest court to review the case even though they don't have to. And that's what you would do with the court. Normally you do that with the Supreme Court of Kentucky, you have to do that with the Court of Appeals here. So it's curious, nobody knows anything about appealing stuff from district court because nobody ever does it, right? But this will be appealed. Most likely. Most likely it'll be appealed. Now, can you imagine a world in which, a procedural world, I'm not talking about do we get to speed, but can you imagine a procedural world in which this doesn't get appealed by somebody? Why would it not get appealed? Can we think about that? Commonwealth, as it stands now, if this were a final order, they appeal it today, right? But it's not. It's not a final order. What has to happen for there to be a final order? It's a speeding case. What has to happen for there to be a final order? It could be. It could dismiss the charges.
And it has to be adjudicated, or like just both the matters?
Yeah, it's got to be adjudicated somehow. How does that usually shake out in a speed? Who's had a speeding ticket? Right. What happens? How does the case end when you have a speeding ticket, Mr. Wiseman? Pay the fine? Well, you just pay it, or do you have to do something else in addition to paying it? You plead, don't you? Even if you just write it down on a piece of paper, you plead guilty, right? And then the court, even though it's quick and dirty, in theory, the court issues a final order that says, yes, you're guilty. Here's what you have to do, right? There's a final order that's issued. What happens if he's found guilty of speeding in this case? Does the Commonwealth then appeal it? They got a conviction. I don't know.
They're in a weird situation.
Yeah, it's weird.
It's like, it's weird because we got what we wanted, but we also got something we didn't expect or want.
If you enjoy this kind of stuff, might I suggest an exciting career in the criminal law? Okay. But let's go back to the world of civil procedure. Civil procedure. And if you had a civil case, by the way, in the small claims court, right, or in probate court, or in something else that happens in district court, you still appeal that up to the circuit court, right? The regular trial court, those appeals go right up to. So if there's an eviction case, you appeal that up to the circuit court, not the Court of Appeals. Anyway, Sarah, you're looking at me quizzically, like you don't believe me.
No, I believe you, to be honest. I finished what
We're rethinking. I don't know. It could be there could be statutory differences from action to action. So asterisk, right? But that's the default procedure. All right. What can you ask for out of these interrogatories in our class? How many of you actually drafted some interrogatories a little bit last semester? You know, or at your job? I'm really going to give you your money's worth today because I'm going to make you the hero clerk of your firm. And the reason I'm going to make you the hero clerk of your firm is because we're going to talk a lot about responding to these discovery requests. And if you talk to lawyers that practice in civil litigation, the one thing that we all hate is responding to discovery requests. It's really hard to hand off that stuff. It's really hard to get a clerk to do it competently. And put all the right objections in and cross all the T's and dot all the I's. It's just tedious, boring work. So if you prove that you can do this to your firm, you'll get saddled with it all the time. It'll be great. Okay? So how do we determine what you can ask for? Well, the gold mine here is 26 Rule 26, let's go back and think about Rule 26. And what does Rule 26 tell us? Well, a bunch, right? But go to 26B. Okay, we did a lot of 26A last time. That's just all initial disclosure stuff. But 26B tells you what you can ask for. Right? And we touched on it already when we did our discovery overview. You can get discovery about any non-privileged matter that's relevant to any party's claim or defense, right? And then you've got a bunch of stuff down here. Now this stuff down here, after you cover privilege and relevance, that stuff down here is important to how you object to the interrogatories that have been posed to you, or the request for production documents that have been posed to you. Let's look at the example that I put up on Blackboard. Everybody knows what Blackboard is, right? You've seen that before? All right. So here, and we'll talk more about these little parts as we go. In this first set of interrogatories, let's skip down to the second part of this. I've got a set of sample interrogatories, right? And then the beginnings of answers to those interrogatories, okay? So, defendant's interrogatories up top, and then halfway through the document, I've got plaintiff's responses, okay? General objections, we'll talk about that in a minute. But the specific objections that are lodged in these, okay? Objection, the interrogatory attempts to subvert the limit on the number of interrogatories set by 3301, blah, 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 blah. Overly broad, not reasonably calculated to lead to the discovery of admissible evidence. This is pretty stock stuff that we use for responding to interrogatories, right? And almost every interrogatory that you answer, if you do this work as a clerk, almost every single one, or as a lawyer, almost every single one should have some kind of objection lodged, just so you are covered. Not all of them, but almost all of them, okay? Because almost every interrogatory or request for production of document that you could propound on somebody could be perceived to be objectionable in some way. And you want to make sure that you're covered up on that. That's what makes this so tricky. But the 26B tells you what you can do with that, okay? Importance of the issues at stake in the action, the amount of controversy, all this stuff basically goes to, is the information that's being sought overly broad for the case, even if it could be relevant, even if it could be something that could conceivably be discovered, right? Is it overly broad? Is it unduly burdensome? In some way, is it vague? We'll look at some of those common objections. But the test that you want to go through in your brain when you're responding to this stuff, and when you're posing the questions too, are you asking for relevant information? Is the question asking for relevant information, something that's relevant to the action at hand? So if we are in an ordinary battery case and I ask the defendant for records in his divorce case, I'm going to object on, or the defendant's going to object on the basis of relevance. Then you want to ask, is it subject to some kind of privilege? The two major privileges that we've already identified in here are what? Attorney-client and work product. Good. Those come up a lot. If what is being asked for is a conversation between attorney and lawyer, that's attorney-client privilege information, right? If it's something pertaining to how the legal claims ought to shake out in the case, could be subject to work product privilege. If it's asking for, the classic example is asking for attorney notes. Okay? That's obviously work product stuff. But then you get down to asking if it's objectionable in some other way. Is it proportional to the needs of the case as per Rule 26B? And that usually comes in the package of this interrogatory is overly broad or unduly burdensome. taking into account each party's access to relevant info. So, for example, if I ask the defendant to tender the police report from the night of the incident, the defendant may object and say, well, you've got equal access to that information. That's a public record. Go get it yourself. Okay? And that's an objection you see a lot, too. Remember the principle, especially when we get to our problems, and we get to our little scenario for today, it doesn't have to be admissible to be discoverable. It doesn't have to be admissible to be discoverable. You can ask for stuff. And when I say admissible, you guys had evidence yet? Who's taking evidence this semester? Some of you, maybe? No? Nobody's taking evidence this semester? So you don't know what's admissible and what's not. Well, you'll learn it. But what were you going to say, Jim?
Well, I was stretching.
Oh, okay. Carry on.
But I did take evidence.
You what?
I did take evidence, but I
You
was
did take
stretching.
Yeah, admissible evidence. So, because you're almost always going to be able to find, evidence is one of those on-the-spot sort of determinations, right? Many times. You can't ever definitively say what's admissible and what's not. That's going to be up to the judge, and the judge does not want to have these evidentiary battles about admissibility during the discovery phase. That happens at trial. Okay? Everybody with me? Yes? Example objections. Some of this stuff is on the samples that I gave you on Blackboard. Some of it not. This is all Rule 26 stuff. Take a minute and read it, and then I'm going to put a little asterisk by the last one. Now, just because you lodge these objections doesn't mean that you don't go on and answer the interrogatory. If you outright refuse to answer an interrogatory, sometimes it's appropriate to do that. If you are responding to interrogatories and you outright refuse to answer the interrogatory, what are you likely to get? We'll talk about it, but you'll get a nasty letter, right? And then you'll get a motion to compel. And then you'll get an order on the motion to compel. And you'll ignore that, and then you'll get sanctioned. And then you'll blame me. I said, well, procedure teacher never told me about this. So, look at the example we've got on Blackboard. Objection, blah, 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 blah. Overly broad, not reasonably calculated to lead to the discovery of admissible evidence without waiving the objections. Plaintiff states, here's the information I'm going to give you subject to those objections. Okay? That's the smart way to do it.
So he's giving the info only?
You give them some info. Yeah.
Can we just tell them, we're not going to give you this information unless you have a motion to compel?
Yeah. Sure you can. Yeah. That is part of the risk-benefit calculus in litigation. Sometimes a judge has got to resolve these discovery disputes. Sometimes you're going to, if you get this kind of, sometimes, look at this example here. Okay. This is a real interrogatory I got in the case. Address of each place you've resided since January the 1st, your social security number, every email address, instant messenger profile name, social media profile, telephone numbers, every social networking application, not limited to blah, 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 blah. Is that overly broad? I think so. Is it compound in the sense that it's a bunch of different interrogatories all hiding in one? Yeah, I think so. Right. Did I still answer it? Yeah. Yeah. And why? Because we're going to go running back to the court every single time there's something like this. We want to provide some kind of answer to the other side. Or you're going to piss your judge off royally. Right? But that doesn't necessarily mean that you give them the moon and the stars. Right? You tell them in your objections, look, this is objectionable. Here's what I'm going to give you. Now, I've had questions too. One cute thing that defense attorneys were trying to do for a while was download your all of your Facebook information and send us the file with everything that's on your Facebook. So all your messages and every post that you've ever made on Facebook and everything. And for those, we say no, right? No. Really hard to make that relevant information. That's grossly overbroad. So there's times to fight and there's times not to. You want to avoid that as much as you can because it's time consuming, it's expensive, and it makes the court unhappy. Now, on this, you will see oftentimes, especially in state court, this last objection, reasonably calculated to lead to the discovery of relevant admissible information, that is no longer in Rule 26 under the federal rules. However, you look at Kentucky's analog, which as we know is 26.02, right? Still shows up here. Information sought appears reasonably calculated to lead to the discovery of admissible evidence. So those rules got changed in the federal system in 2015, and Kentucky is not there yet. Okay? Check your state rules. Questions? Got this? Keep going? Yeah. Timelines. We need to know about time. Per the rule, pretty simple. State rule 3301 for interrogatories, 3402 for request for production of documents. Remember we said per 3301, we talked about this in the context of interrogatories, but request for production of documents is the same thing. And the rule is 3402 because Kentucky just likes to beat that annoying, so it's not 3401, it's 3402, but you can serve these interrogatories and request for production of documents along with your summons and complaint if you're the plaintiff. And if so, the defendant has 45 days to answer. In the federal court, remember, you don't get to serve any discovery on anybody until the court says so. File your complaint, you wait your case management conference, the court sets all the dates for the case at that CMC. That's easy, right? Says it right there in the rules. Easy. What if you need more time to respond to interrogatories or requests for production documents that have been propounded on you? What do? Say again? Yeah. Can you move the court for more time? I guess. But it's really, really common to get extensions of time to respond to interrogatories and requests for production documents. Okay? Really, really common. In fact, there's a rule, Rule 29, that contemplates that the parties are going to sort of collaborate on this and get together, and that you don't need a court order necessarily to extend the amount of time for interrogatories and requests for production of documents, because you don't even file this stuff with the court. Right? Most courts. You're not filing these documents with the court. They don't care. Work it out yourselves. That's sort of the attitude that courts have about discovery in general. You all work it out, we'll get involved when we have to. So ask the other side. And then, assuming that the other side says no, you then go running to the court. Again, maybe, if you really want to. Or maybe you just tender them to the other side when you tender them. And if they're really mad at you, then they can go to the court. Right? Tendered my responses 31 days after I was served with the interrogatories. If I'm the party that propounded those interrogatories, am I going to go running to the court and say, please hold the other party in contempt because they didn't tender their responses until one day after the deadline set by the rules? Probably not going to happen. Probably not going to happen. So try to agree on this stuff with your opposing counsel. State Rule 3301 says you get 30 interrogatories. The Federal Rule 33 says you get 25. That is often changed in the case management plan. And you will often see practitioners propound more than 30 interrogatories. I'm sorry, more than 25 interrogatories. Especially practitioners that are used to state court, that then wade into federal court, and they're like, oh yeah, I still get 30 here, but you don't, you get 25. And that might be changed by local rule too, right? Because that's part of the fun. And so because you only get 25 or 30, you end up with monsters like this. Everything you've ever used to identify yourself ever in the history of time. Rules do not set a limit for you on your request for production of documents. Does that mean that you can do what I've seen done in some cases and tender 200 requests for production of documents to a single party? You're kind of asking for a protective order if you do that. You're kind of asking for the other side to go to the court if you do something obnoxious like that. But under the rules, you can try. But then you get into arguing that magic language in Rule 26B about whether this is proportional to the needs of the case, so on and so forth. Right? The reason I point out 33B5, 33B5 requires objections to these interrogatories, which you will have when you respond to interrogatories. But objections to the interrogatories are required to be signed by the attorney. Normally the way I see it, I have seen this where attorneys will go through and in an answer like this, put a signature line and sign each and every objection before the answer. I've seen that, right? And so you have like 50 signature lines from the attorney before you get to the end of the document. I don't think that's what the rule wants. And far more often in practice, what I see is just plain old signature block at the end by the attorney. Plus, you got to have a verification page for your interrogatories, because those are answers that your client gives under oath. Right? They have the same effect as an affidavit or deposition testimony or testimony in open court. Okay? That's an important thing to remember about your interrogatories. Whatever you put in there is going to be your client's testimony. Questions about any of that? Good? Yes?
Just the answers, correct? Like just
Just the answers are gonna be considered, yeah, as opposed to what, like the
Well, I mean,
objections?
like, obviously, like plaintiffs would be, like they don't, the plaintiffs don't need verification.
Oh, when you're propounding them, no.
Okay.
You don't verify the questions you send us, that's all counsel stuff. Interrogatory responses. So, what you will see, because you can do it under the rules, right, is parameters set by the propounding party about what all these terms mean. Right? So you have a definition section. What does person mean? What does and or mean? Date, right? So there's no ambiguity. Do you write these anew every single time you respond to production of documents? No, you don't. You just cut and paste from somebody else's document. If this is the sort of thing that appeals to you, you will love civil litigation. You see what the asking party has done. And then, conversely, when you're answering these things, you can set forth a bunch of general objections. What kind of force do these general objections have? I don't know. It's going to be a question from jurisdiction to jurisdiction, and probably one that not very many courts have said anything about. But stuff like, we object to the extent that these interrogatories and requests for production of documents seek information presently unknown by plaintiff. And that's the kind of thing that seems like obnoxious lawyer stuff until you definitively answer an interrogatory a certain way for your client. Name all persons, for example, name all persons who have knowledge about the incident that happened at Wicks Pub on the night of June 3rd, 2019. So you gotta answer an interrogatory like that. You don't lodge any objection, you just say, here are all the people who have knowledge about that incident. And then, when your client is getting grilled under the hot lights at a deposition, and the opposing counsel puts your interrogatory responses in front of that witness, in front of your client, as they will do, right? And says, remember when you gave these interrogatory responses? Yes. Did you realize you were under oath? Yes. Is that your signature on the verification page on the back there? Yes. Okay. You said that all the that have knowledge about this incident are this person, this person, this person, and this person. Well, what about John Smith, the repairman, who was there the whole time? And your client's like, I didn't know anything about John Smith, the repairman who was there the whole time. That gives you a chance, if you've made this objection, to bloviate on the record and say, look, we made this objection. We didn't know everybody who was there at the time. That information was presently unknown by the plaintiff at that time. It's a goofy example, but that's the kind of stuff that happens in civil litigation. Isn't this fun? Obviously, you can't serve discovery requests on non-parties. This is just as between plaintiffs and defendants. That's it. Any other information that you're seeking from any third party, we've already said, has got to be subpoenaed. Look at your local rules to see if there's any additional rules that apply to interrogatories or requests for production of documents or any other device. And how do we go about doing that? I've said it before, I'll say it again, you need to know it. Let's say local, look it up here in America's search engine, Bing. Local rules, Western District of Kentucky. Probably a bad example because there are no local rules. There are, but it's not very good. All right, here we go. Joint civil local rules. Then I scroll down and I look. Remember, these local rules correspond to the rules of civil procedure, the federal rules, right? So if there's nothing for rules 33 and 34, then there's probably not a local rule that modifies interrogatories or requests for production of documents. Everybody understand that? No? You may have a local rule question on your final exam because we talk about it so much in here. And I'm so confident that you guys understand how to use these. There is a Rule 26, right? Which you can't click to, that would be too easy. There's some modification to Rule 26, the content of discovery responses. There's nothing about interrogatories or requests for production of documents specific, okay? That varies from jurisdiction to jurisdiction. If you're answering in the state court, look at that county's local rule. What if you don't like the objections from the other side? Well, we've already said. You send over a nasty letter, you make a motion to compel, we'll work on all that. Now there's one big thing in Kentucky that I didn't assign you to read, but you've got to know. Right? And this happens in some other jurisdictions too. But if you are asked the question, provide a computation of all your damages in an interrogatory, and you just demur, like, I don't know, objection, that question's overly broad and we're still in discovery and I don't want to answer that question right now. I'll tell you when we get to trial. What Kentucky courts have said, probably some changes in the rules, is that if you do that, it's going to kick you out of categories of damages. And maybe kick you out of all damages. Look at this language, you can see it from the case of Fratsky versus Murphy. In the Fratsky case, you may have heard Kentucky lawyers talking about Fratsky violations, Fratsky this, Fratsky that. Getting Fratsky is a thing. Which sounds kind of dirty, and it is. And it is. Because look what happens in this case. Long story short, they tender interrogatory requests saying, give us computations of your damages. What are your damages? Over and over and over, the defendant asks, what are your damages, plaintiff? And the plaintiff says, we got some medical bills, and the rest of it we're going to ask at trial. We're going to ask the jury for these damages. So get lost. The categories of damages that poor Miss Murphy was asking for after she got plowed into on the picket line. Pain and suffering, medical expenses, future medicals, lost wages, permanent impairment of power to labor and earn money. They give her all that. The jury gives her everything. $25,000 for pain and suffering, $33,000 in medical expenses. Right? These are your special damages. We said $33,513.62. Definitely special damages. $12,000 future medicals. All the rest of these are general. Right? $27,500 for lost wages, $25,000 for permanent impairment of power to earn labor and earn money. That's what the jury gave her. The trial court says, okay. Court of Appeals and the Supreme Court say, no, you get your special damages for your medical expenses because you tendered proof of that, and the rest of this, you didn't tell the other side ahead of time, so we're taking it all away. Taking it all away. Put some amount. If you are asked that question as a plaintiff, and you will be, of course, put some amount for that. Even if you don't know yet, set a high ceiling for yourself. And I talked to some of you about that in your initial disclosures too, right? Same kind of thing. Questions about that? Super important when you're responding in the state court. Yeah?
I'm just curious, the attorney for Fransky, whoever that was, before that was decided, what do you think, like, is that a malpractice that they didn't include that, or prior to that being decided, or?
I don't know how that shook out, actually. I don't know.
Not important, but I was curious.
Yeah, it could very well be. I imagine there was a bargain. Don't know if there was a malpractice. Okay. So look at problems on page 503. These should be pretty easy. I think they're good problems, but they should be pretty easy if you're paying any attention. The last couple of classes. And most of these answers are contained right there in 26B. Question at the deposition. Or pretend it's a question in an interrogatory because all the same rules apply. Based on your observations at the time of the accident, who was at fault? Is that okay?
No, it's asking for a legal conclusion.
Okay. This happens at a deposition, right? Under our hypothetical. Do you instruct your client not to answer that question? You lodge an objection? You can object, it calls for a legal conclusion. Okay, all right, I don't disagree with that. Yeah, what were you going to say?
I was just gonna say.
Right. Objection, calls for a legal conclusion. And then what?
If they continue to press the issue, I mean, another whole situation is to make sure your client says, in my opinion, so that it doesn't, so that kind of like.
You said based on your observations. I'm okay with that. Somebody had a hand up back here.
I
Yeah.
was gonna say, usually if you just object, and then you just.
Yeah, answer the question. Right? Same goes for interrogatories, right? I think the information is perfectly discovered. Based on your observations at the time of the accident, who was at fault? Objection calls for a legal conclusion. You can answer anyway. Of course they can give an opinion on it. Of course they can. Nothing stops you from asking that question, and you should. Next, same facts as number one. Next question. Did you hear Vesely express an opinion about whom she believed was at fault? Get into evidence, you'll realize that this is, just in its raw state, inadmissible hearsay. Right? Is that something that's okay to ask? Yeah.
Yeah, you can still ask her, but you can't miss it.
Does it have to be admissible to be discoverable? We've already said no. No. Right? It's discoverable. Perfectly fair question to ask in a deposition. Perfectly fair question to ask in an interrogatory. Yeah.
Can you still object?
Yeah.
What are you gonna object on?
Whatever. You might object to the form of the question on that. You don't really make a hearsay objection in a deposition. Right? Object to form, and then later on, let's say, okay, because play that out in your head. object to the form of the question. And then the witness dies, right? And the opposing party says, Judge, the only testimony we have from this critical witness is in this deposition. And I want to play the deposition for the jury. You haven't lodged an objection within that deposition to the hearsay. You might have a judge, this shouldn't happen, but you might have a judge that says, you didn't object on the record at the time the deposition was being taken, so we're just going to let in this hearsay. Why not? So yeah, object, don't get carried away with it. When we get to the depositions section, I hope I remember this, but I want to share with you guys this case where this big firm lawyer got sanctioned actually the whole law firm I think got sanctioned for objecting to every single question asked in every single deposition because that's what they were being taught to do. So incredibly annoying. Incredibly annoying. And that's basically what the court said. You don't have a basis to object to every single question that's asked in a deposition. That's annoying. You get sanctioned. In the same Smith versus Jones case, Smith sends Jones an interrogatory asking, state whether you have automobile insurance. Is that discoverable? Who says yes, it's discoverable? Who says no, it's not? Now that you've looked around the room to see that everybody else says. Of course it's discoverable. You have to turn that over in your initial disclosures. Remember 26A? Of course it's discoverable.
Hey, Professor Cannon?
Yeah.
What if they ask you, like, have you ever applied for PIP? And if so, what were the details of that accident?
But why are we going down this rabbit hole? You're just trying to get me to talk so you guys don't have to do the written work. It's not going to work. What if they applied for PIP? It is going to work. What if they ask, did you apply for PIP? And then what? Sorry.
Yeah, so I get this all the time. It's like they want to know every time a person's filed an insurance claim.
Oh, okay. Yeah.
Um,
No, I think that's discoverable.
What's that?
I think that's discoverable.
Yeah.
Yeah.
Okay.
Yeah, I think so. I mean, it depends on what the scope is. But, putting my defense hat on, what do you think about that? Yeah, I mean, you want to know how many times, if you're doing a regular car wreck case, you want to know how many times the other party has been involved in car wrecks. Yeah, I think it's perfectly relevant, perfectly discoverable. Whether or not it's admissible is a different question, right? But I don't, now if you said, how many car wrecks have you been involved in, and you've got a 50-year driving history. Like, let's go back to the beginning, when you first got your license, when you were 16, and tell me all the fender benders and traffic tickets that you've ever had. Then you can start getting into the idea that this is a little overly broad. It's still gonna, if somebody wants to drag them over those coals in a deposition, there's not a whole lot you can do. Yeah.
So is information that's as specific as like an insurance policy number, is that discoverable?
Insurance policies are discovered.
So I just didn't know if they could know the person's specific like policy number.
Sure.
I figured they could know like the insurance company, but I didn't know if they.
Absolutely.
Okay.
Absolutely. They're entitled to that policy
Okay.
in most cases, right? If there's a policy that provides coverage, they're entitled to it by the rules, specifically.
Gotcha. I didn't know if like an insurance company would have to like be required to turn that over.
Well, the party is required to turn it over.
Gotcha.
You could subpoena it from the insurance company, theoretically, right? But the party's required to turn it over.
Gotcha.
plaintiff is seeking compensatory damages for lost wages and punitive damages. Can the plaintiff get tax returns from the defendant in order to assess punitive damages? Now, why would you need tax returns to be able to assess punitive damages?
To like see how much money they have.
Yeah. Why would you need to see how much money they have?
So you can ask them.
Why is that pertinent to punitive damages, though? You're right there. Drive it home. Why is that important to punitive damages?
With like punitive damages, you're kind of just kind of like sticking them essentially. So if you ask for like an outrageous amount that you're not gonna be able to pay, then you'll probably get thrown out or something like that. But if you're within the realm of like possibility, then probably allow.
That's right, yeah. Everybody can hear him. Punitive damages are meant to punish, right? Punish the defendant for their wrongful action. Remember when we looked at that opioid litigation that resulted in a big giant verdict, $572 million in Oklahoma against Johnson & Johnson. Right? $572 million. Well, in fact, the state of Oklahoma was seeking $17.5 billion in that. $572 million does seem like a lot of money, but if you're trying to punish a defendant like Johnson & Johnson for their wrongful conduct, well, they pull in revenues of about $15 billion a year. So even $17.5 billion is not really, that's not making the defendant feel the pain for ruining countless lives by putting poison on the market. But never mind, I digress. All right. So, let's answer the question. Is that discoverable? Can the plaintiff ask for the defendant's tax returns? Who says yes? Who says no? Who says maybe? Somebody changed their answer. Right? It is really common to ask for tax returns. Right? Really common. And I'm coming from a mostly litigating employment discrimination cases kind of background, so take what I say with a grain of salt. In my practice experience, it's really common to ask for tax returns, okay? It's also really common to object to someone asking for those tax returns. And it depends on how far back we're going to. So the question here is not really so much, is this discoverable? Because I think the answer to that, the most simple and basic answer you can come up with is yes, it probably is. Right? But how can you limit that in scope? Right? On the asking side and on the responding side, is there a way to limit that? Why would you want to limit it if you're asking? Well, it might be more likely to get what you're going for. But if you're asking for I want all the Smith's tax returns since the 1980s. I don't know about that. That's a little broad. Why do you need all that? How is that relevant to the action? Is it proportional to the claims and defenses? I don't know. Okay. So it's something that you might want to make a little noise about, but ultimately probably going to have to part with that information in some way. Jones wants to file a motion to dismiss because Jones is a defendant. That's what defendants do. Jones has a copy of the statement from Smith that directly contradicts one of Smith's claims. The interrogatory says, state all facts which you have disclosed to your attorney and to other persons about your claim. Not only object, right? Not only object. No, you can't answer that. You can't answer that. Attorney-client privilege. Right? Let's pretend that the attorney part isn't there. State all facts which you have disclosed to all other persons about your claim. Can you do that? Who says yes? Who says no? Those of you who are saying no, what's your basis for not turning over that information? Go ahead.
I think if you just said all other persons, that would include your attorney. I mean, you didn't say attorney.
Yes, that's true. Okay. So, state all facts which you have disclosed to, that's right, yeah. No, it's really good thinking. It's good lawyerly thing. State all facts which you have disclosed to anyone who is not your attorney about the claim. Is it still objectionable? Yeah.
I'd say yeah, because I think you could run into some other privileges where it's too broad or
What privilege is it?
like spouse. I don't know.
Yeah.
Well, if there's if there are like medical claims involved, there you could run into like doctor-patient confidentiality, and also logistically, how are you going to remember who all you've talked to about your claim? Because it says all other persons. That could be anybody
Yeah.
who's not even a party.
That's right. I think, yeah, and I think you lodged an objection based on that. And what's your objection?
Way too broad.
Way too broad. Overly broad. Right? Unduly burdensome. And then you go on to answer it in the best way that you can, leaving out the privilege stuff, leaving out anything you can't remember, right? But lodging those objections is important. Somebody had a hand up over here. Yes.
My question is, I mean, if you've spoken, like, whatever you talked about to your attorney, and then you spoke about it to other people, have you waived that privilege?
No. No, not necessarily. Right? So you've not waived the privilege as between, that's, I mean, a waiver of privilege is a different thing from you just having to disclose the stuff that you talked about with other people. Now, if there were third parties in the room while you were discussing it with your attorney, yeah, then you probably waive that privilege. Right? But I don't think that the other side can credibly argue that there's been a waiver of attorney-client privilege just because you've talked about the same stuff that you talked about with your attorney with somebody else. You know, the stuff as between attorney and client is still not discoverable in any universe. Product liability case. Following interrogatory. State whether the defendant has made any subsequent changes to the product after the accident which gave rise to this litigation. Right, nobody's had evidence, right? But that's essentially what the question is. The question is one of admissibility. So what you'll learn in evidence is that in products liability type cases, or in any type of case, right? Curative measures taken after the fact. So let's say someone comes onto my property and falls in a hole and breaks their leg because there was some sort of concealed defect that I knew about on the property. Then I later go and fill in that hole after the injury's already happened. The evidence of me filling in that hole is not going to come in at trial. That's inadmissible, okay? Subsequent curing of a defect, subsequent repairs. Products liability case, defendant puts an unsafe product on the market, it kills a bunch of people. After it kills a bunch of people, they fix it to where it's not killing people anymore. The evidence of them fixing it doesn't come in. But still discoverable. Still discoverable. You can't talk about it in trial, but it's still discoverable. Most things are. This is a fun one too. this is fun not just because of the perennial hysterical lawyer meme of the law firm of Dewey, Cheatham, and Howe. But I've heard that one before. Let's go. What's the scope of discoverable relevant information? Let's think about how you're going to pose this, right? As plaintiff's counsel, how do you craft an interrogatory that is not too objectionable? Maybe a little objectionable, because they're going to object anyway, but not too objectionable. Right? What do you want to ask for? That's essentially what this question asks. What do you want to ask for? Of course, you've prepared these problems because they're there in the syllabus. So, what'd you come up with? Huh?
Did you ask about, or did you ask the names of their employees?
I sure would. As a baseline, names of current employees? Definitely. No question about that. Yeah.
Possibly the people that have applied and the people that have, the firm has interviewed.
When? Forever?
I guess for the past 10 years.
Yeah, maybe. Maybe. And if you get 5, great. Right? Everybody hear him? Who has the firm interviewed in the last 10 years? All the names of all the interviewees. Seems a little broad. Let them sort it out. We'll give you 5 years, great. You have
Can you get like any performance reviews that you might have had when you were there over the summer? Like,
Sure. Sure. I would ask for that. What else? Anything else? Yeah.
Like any disciplinary action taken against the hiring committee, like internal disciplinary stuff?
Sounds relevant to me, but I'm a plaintiff's lawyer. So, yeah.
Would you ask for like any communications that involve what's his name? Greenwich. So like anytime they talked about him or like hiring him or whatever.
Most definitely. Yeah, most definitely. Once you get the list, and in fact, I'd go farther and say, once you get the list of prospective hires and people that interview, you can ask for correspondence about those people. Right? Within a certain period of time. Anything else? We beat that dead horse? You get how this works, right? It's easy. Here's your scenario. We're not doing it today. Bring it to me on Wednesday. Okay? So much time. So much time to do this, and it's so easy. The interrogatories, you can talk about this. I don't care. Like, you can talk about it as much as you want over the week. I don't care. Right? So I'm not going to agree. Just want to look. But bring it to me first thing on Wednesday. You're a plaintiff, you're Kentucky State Court. Answer those interrogatories and one little request for production of document that I've got on Blackboard. Don't worry about formatting. So I'm not looking for, don't put, if you want to put a bunch of general objections and the heading and all that stuff in there, that's fine. I just want you to, you don't have to do that. I just want you to answer the questions the way you would answer them if they were in the middle of a document. Okay? Does that make sense? Questions? Bring me that on Wednesday and show me you understand how to do this stuff, and we will move on with our